Our next speaker is Mr. Hartley Nathan. I'm not sure I'm on. Okay. Hartley is a partner in the firm of Minden and Gross, and I've known Hartley for a number of years. Hadn't realized till I read all this what tremendous academic credentials he has. He really doesn't appear that bright in daily conversation. I won't bore you with all the honors and achievements. Hartley practices in the commercial corporate area generally and pretends to know a bit about government assistance programs, and that's what he's here to talk to you about today. But he's much more interesting if he talks about Sherlock Holmes. Now, there's something he really does know a lot about. In any event, I suggest you pay close attention. This is the one opportunity we ever have to help our clients get back from the government some of the atrocious sums of money we pay to them. So I'll turn you over to Hartley on the subject of government assistance programs.
Thank you, Jack. I don't think Sherlock Holmes ever applied for a government loan. I've been asked to speak to you today on the topic of government assistance programs in Canada. My lecture will proceed from the basis of my experience as a lawyer who acts for small and medium-sized companies. A client's business has reached a point where substantial financing is required for one of many purposes, such as plant expansion, the manufacture of a new product, equipment purchases, or a client wishes to commence a new manufacturing business. The client has told me about his or her future plans. I hear a number of buzzwords which suggest the situation to be one where government assistance in one form or another may be availed of to facilitate the realization of the project. A lawyer should be aware of the numerous programs available, should develop an understanding for the type of businesses the federal and provincial governments wish to assist, and should also have an appreciation of the specific objectives particular assistance programs are being tailored to meet. Government assistance comes in many sizes and shapes: outright cash grants, cost sharing, repayable loans on favorable terms, forgivable loans, design and technical assistance, management counseling services, information services, equity participation, and tax incentives. At present, there are more than 100 major programs offered by the federal and provincial governments. I do not intend to review the broad spectrum of programs available, as this could not be done in the time allotted. The lawyer will find that in most cases he or she does not play a major role in negotiating and implementing a government-assisted transaction. After the initial contact is made, the client normally deals directly with the agency involved. The lawyer, however, should try to spot potential government sources of funds which may prove helpful to particular clients and which the client might otherwise overlook. The lawyer may be of immense help to his clients if he's able to direct them to the proper sources of government assistance. To this end, the lawyer himself must be aware of the sources of information at his and his client's disposal. This can be done in two ways. First, both the federal and provincial governments operate business information offices. The federal government, through the Ministry of Industry, Trade and Commerce, or ITC, operates a network of business information centers throughout the country. The Ontario government, through the Ministry of Industry and Tourism, or MIT, operates a network of business counseling offices. Now, I should add that every time I prepare a paper for presentation or publication, somewhere between the time of preparation and the time of presentation or publication, one of my leading cases is overruled, a new statute's enacted, or something else happens. All that happened here was the Ontario Ministry of Industry and Tourism has been divided into Ministry of Industry and Trade Development and the Ministry of Tourism and Recreation. But since it doesn't come into effect until March 31, 82, I'll continue to refer to Ministry of Industry and Tourism, or MIT. Now, the staff at either ITC or MIT is well versed in the broad range of government services available at the federal or provincial levels. Secondly, there are a number of publications available published by the government, private companies, and several major accounting firms. These can provide the lawyer with up-to-date information as to what government programs are available at any given time. The lawyer should have some of these publications in his library. Any lawyer involved in a corporate commercial practice would be well advised to browse through these publications to see what's most relevant to his client's interests and needs. From time to time, update his or her knowledge of the programs as they change. As previously mentioned, government assistance programs take a variety of forms. There are some broad distinctions which may be made in distinguishing and classifying some of these programs. These are discretionary and non-discretionary programs. Examples of some non-discretionary programs are the various tax incentive provisions built into the Income Tax Act, such as capital cost allowances, deductions for research and development expenses, or for certain energy-conserving measures. These incentives are obtained automatically by the taxpayer fulfilling the criteria set by the Act and the filing of the appropriate returns. Most specific incentive programs are discretionary. The borrower must apply to the government agency and convince the agency why his project deserves government assistance. This paper concerns itself with those discretionary programs which are designed to assist the small to medium-sized private business. The vast majority of government assistance programs are aimed at Canadian enterprises in the manufacturing and secondary processing sectors. Business people in the retail or wholesale sectors may have recourse to the FBDB and to various management counseling services provided by various government agencies. There are very few, if any, financial incentive aids available to these sectors. The service sector is also not provided with any specific incentive programs, with the exception that service businesses, which cater primarily to manufacturing or processing concerns, such as tool and die shops, will normally be eligible for programs designed to help the manufacturer. A project or venture is usually required to meet specific conditions. Some common conditions are the following. There must be a demonstrated need for assistance, not just financial need. It could also be a need to share risks. The presence of sound corporate management or an achievable program to acquire such management must be demonstrated. The project or venture must be workable. That is, it must involve a product or process with market potential. Participants must have a reasonable equity in the venture. Program administrators usually favor only a proposal that involves a project or process that will create employment, increase exports, provide substitutes for imports, or stimulate the economy of a depressed region. If the program includes loan funds, the enterprise must demonstrate its ability to repay the loan. Many of the government programs are tailored to meet very specific and narrow demands, and thus are in a constant state of flux. I've decided to review a selected number of more important and often resorted to programs, both at the federal and provincial level, with a view to showing how the programs are structured and how a business person may go about taking advantage of them. Most programs can be categorized as being incentive or last resort schemes. The incentive programs are normally aimed at specific industries or specified types of industries. They will, by and large, provide some type of financial relief to the investor, whether in the form of grants, reduced interest rates, or subsidies, or a combination of these. The last resort programs of which the FBDB, as a prime example, will provide assistance to a broad spectrum of different types of businesses in cases where financing is unavailable from conventional sources. This assistance is rarely, however, less costly to the borrower than conventional borrowing. Another distinction to bear in mind is how various programs are focused. You'll find most federal programs tend to channel funds into those enterprises which promote research and development and productivity, as well as those which enhance Canada's balance of payments, that is, exports. The provincial programs, on the other hand, tend to promote job creation and such items as domestic manufacturing and tourism. The distinction may be relevant in assessing where agencies will best be able to help a particular client. It's entirely possible to receive aid from both levels of government and various programs at the same time. I'd like to refer to a couple of the federal programs. First, the Federal Business Development Bank. Certainly the FBDB is the most publicized, the most extensively used government assistance program in Canada. Section 4.1 of the Federal Business Development Act sets out the objects of the FBDB. The objects are to promote and assist in the establishment and development of business enterprises in Canada by providing financial assistance, management counseling, management training, information and advice, and such other services as are ancillary or incidental to any of the foregoing. Subsection 2 reads, "The corporation in carrying out its objects shall give particular consideration to the needs of small business enterprises." Now, the annual report for the FBDB for the fiscal year ending March 31, 1981, disclosed the average size of a loan was $61,000, up from $52,000 in the preceding year. Now, almost any active Canadian business is eligible for a loan from the FBDB. The major recipients are businesses in the manufacturing, wholesale, retail, and tourist industries. The bulk of FBDB funds are used for term lending to assist in the purchase of fixed assets such as land, buildings, machinery, or equipment. The FBDB will also provide loan guarantees to enable businesses to obtain working capital and will also engage in equity financing in certain instances. It must be remembered that the FBDB operates like any other bank with some essential differences. It's a federal government crown corporation created with a view to assisting business, and as such it will agree to make higher risk loans that would ordinarily be the case with a conventional bank. There's a further essential difference to an ordinary bank. The FBDB is a last resort lender. The FBDB officer will require a letter from the borrower's bank stating that financing is unavailable, or will contact the borrower's bank loan officer to confirm that that is indeed the case. Funds will be loaned out at normal prime rates plus. The FBDB, however, charges a 3% guarantee fee for loan guarantees to conventional lenders. So a normal interest rate might be 1 to 1.5% over prime for the loan itself, and with the FBDB's guarantee charges, the cost of the loan for the borrower could be increased substantially. It should be pointed out, however, that the FBDB can be more flexible in tailoring repayment schedules and in many cases will allow a borrower to postpone the principal and/or interest payments for varying periods of time, usually up to a maximum not exceeding a year. It's to be noted that although the FBDB may be a more benevolent lender and will go further to renegotiate or modify loan conditions where the borrower finds himself in a tight spot, the FBDB is not in the business of losing money and will realize on its security if things turn out badly. Now, some of the criteria used by the FBDB in evaluating a loan application are as follows. Management. The loan officer will focus on the experience that the applicant has in the type of business he proposes to establish. Ability to repay. The pro forma cash flow statements in the business plan will be carefully scrutinized. Security. The FBDB will require its position is adequately secured, even if it is only a second position behind a private sector lender. Amount of investment by the principals. This primarily is looked at as a sign of commitment by the principals. Working capital. The FBDB does not normally contribute funds for working capital, but will require adequate working capital to ensure the liquidity of the business. Viability of business. The borrower must demonstrate the business is a viable proposition. Although the FBDB's financial services are relatively well known, less well known are the management services it provides. Counseling Assistance to Small Enterprises, or CASE, is a program under which small businesses, for nominal fees, get as consultants retired business executives. Virtually any type of business enterprise in Canada is eligible for assistance under this CASE program, provided that the enterprise does not have more than 75 full-time employees. The charge for the service is $35 per 7-hour day for each counselor assigned. The second federal program I wish to refer to is the Enterprise Development Program. The objective of EDP is to encourage the growth of the manufacturing and processing sectors of Canadian industry by providing assistance to qualified companies to improve their viability and their international competitiveness. The program focuses on promising firms prepared to undertake relatively high-risk adjustment or innovative projects which could yield attractive rates of return. At present, the emphasis on export-oriented manufacturing firms is very high. Eligibility is generally limited to small and medium-sized businesses engaged in manufacturing or process operations. Now, you'll recall that I said the FBDB is a lender of last resort. To be eligible for assistance from the EDP, one has to be in even more dire straits than with normal financing and even FBDB financing not being available to the applicant on reasonable terms. Therefore, EDP is usually the last of the last resort lenders. The type of assistance that it has available is of some interest. It falls into 3 basic categories. First, provision of insurance of up to 90% in support of term loans made by private lenders to manufacturers and processors. Secondly, the provision of outright grants, normally up to 75% of eligible costs for research, development, and design projects. The project must represent a significant burden on the company's resources. Thirdly, contributions normally up to 75% based on the company size criteria may be made available to engage consultants for market feasibility studies, productivity enhancement studies, and product development for design and pollution technology projects. Generally speaking, each of the various forms of assistance has its own eligibility criteria, and these should be checked out very carefully with the EDP people. The third federal program that I want to refer to is the Small Business Loans Act. The Act provides a program to guarantee loans made by conventional lenders to small business enterprises in a broad spectrum of industrial sectors, including manufacturing, transportation, construction, communications, service, retail, trade, or real estate. The federal loan guarantee is particularly attractive in cases where the bank, commensurate with the risk factor involved, would normally charge the borrower a substantial percentage above the prime rate. In such cases, a loan guarantee by the federal government would serve both to secure the lender and reduce the cost of the loan to the borrower. The rate of interest on SBLA loans is set at 1% above the prime lending rates of the chartered banks and fluctuates with changes in prime lending rate for the duration of the loan. The maximum payment period is 10 years. The loan must be secured. and loans for refinancing existing debt or working capital requirements are not eligible under SBLA. A small business is defined as one whose estimated annual gross revenue does not exceed $1.5 million during the year the loan is made. All chartered banks are authorized to make loans under the SBLA, as are other designated lenders who have applied for the status. The loan applications under the Small Business Loans Act are made by the borrower to its bank. If the bank approves the application, the bank will in turn apply to ITC, which administers the program for the federal government, for its approval. If the bank is willing to make the loan, the government will assist if the borrower meets the criteria. Unlike the FBDB, it is not last resort borrowing. I'd like to focus for a minute on some programs offered by the Ontario government. First, the development corporations. The ODC is the name given to one of the 3 development corporations of the Government of Ontario, the other 2 being the Northern Ontario Development Corporation, or NODC, and the Eastern Ontario Development Corporation, or EODC. Assistance is channeled regionally to businesses and industry through these Crown corporations. ODC serves Central and Southwestern Ontario, NODC, Northern Ontario, EODC, Eastern Ontario, and the development corporations are collectively referred to as the ODC. The ODC is responsible for the administration of many of the specific programs offered by the provincial government. Now, the ODC's lending activities are carried out under the Ontario Business Incentive Program, or OBIP as it's called, which is tailored to provide assistance to certain designated industries such as secondary manufacturing, service industries and supportive manufacturing services, industries which export goods or replace imported goods, and tourist operations. And businesses which provide job creation and export potential will benefit the most from this program. The development corporations parallel the FBDB in many respects, the most significant being that each is a last resort lender. ODC funds are not available to applicants able to secure funds from conventional lenders, company resources, or its own management. There are some significant differences. The FBDB operates like a conventional bank when it comes to loans, but the ODC is specifically commissioned to provide last resort assistance at lower rates to borrowers with high risks. They seem to be less concerned with securing their position and are more willing to take chances with specific borrowers. Applications for loans of up to $100,000 are approved by senior management of ODC, but over $100,000 by the Board of Directors of the relevant corporation, which meets monthly. Applications over $250,000 must be approved by the Ontario Cabinet. The ODC may offer a total or partial guarantee of a loan from conventional sources where adequate funding would not otherwise be available, thus encouraging private lender participation. Under the Export Support Program, ODC may assist with the financing of foreign receivables for Ontario-based exporters who are experiencing difficulties in financing sales to foreign countries. Lines of credit are established under this program and carry an interest rate fixed for a one-year period. The development corporations offer venture capital loans to assist small Canadian-owned businesses in Ontario to introduce new technology in the industrial field that will help diversify Ontario's economy. The maximum for a venture capital loan is $500,000. Another ODC-administered program, which is little known but of some interest, is the Foreign Subsidiary Buyback Program. It is one of the few programs in Canada which is designed to allow Canadians, particularly those in management positions of foreign subsidiary companies, to repatriate the companies from their foreign parents. Assistance can be provided to Canadians to purchase viable foreign-controlled manufacturing operations that might otherwise be shut down or sold to non-Canadians. Direct loans may be made up to a maximum of $500,000 and loan guarantees up to a maximum of $1 million. Now, the Ministry of Industry and Tourism. Its objectives are to stimulate the economy of Ontario, help create jobs, find markets for manufacturers, assist in industrial expansion, and encourage new technology. It has a number of coordinated programs to assist Ontario industries and businesses in specific sectors. The Division of Small Business Operations maintains offices throughout Ontario to assist and implement ministry programs and to provide manufacturing, marketing, and financial services. In addition to loans available through the development corporations, financial assistance is available within MIT through a number of administered programs. Some of these, while small in monetary amount, may be of interest to lawyers because of the availability of funds to smaller types of businesses for whom they act. Lastly, the Small Business Development Corporation, the SBDC. This program provides a grant equal to 30% of the amount paid for treasury shares by individuals and certain prescribed organizations, and a tax credit equal to 30% of the amount paid in the case of a corporation with respect to investments in shares of a registered SBDC. The credit is applied to reduce Ontario corporations' income tax and may be carried back 1 year and forward for an indefinite period. The investor must ordinarily be an Ontario resident, and in the case of a corporation must be subject to Ontario corporations' income tax. The SBDC in turn invests its funds in eligible small businesses. This program may be of interest to practitioners who have clients who wish to invest funds in venture capital enterprises. The SBDC must ultimately invest 70% of its equity capital in eligible small businesses via the purchase of new equity shares which carry voting rights. The SBDC may not control the small business enterprise, for it's the intention of the Act the operating shareholders maintain control of the business. The Act does not allow persons to invest in their own corporation to be eligible for the 30% grants. Accordingly, the SBDC and the small business enterprise it invests in must be at arm's length. Investors in the SBDC cannot be related to the major shareholders in the eligible small businesses. The SBDC is required to invest at least 40% of its equity capital in small business by the end of the first year after registration and 70% by the end of the second, and must maintain the 70% investment thereafter. Now, I'd like to conclude with a discussion of the role of the lawyer. Where does the lawyer fit in trying to help the client obtain government assistance? In the pre-application stage, the trick is to spot a client as the potential recipient of government assistance. The lawyer may have a role in identifying the need or opportunity for government assistance. The hearing of certain buzzwords or phrases from a client should trigger further investigation. Let me list some of these main buzzwords or phrases to listen for. Creation of new jobs, potential for increased exports, replacement of imports, activity involving research and development, large amount of risk involved, improved cost efficiency, potential for economic benefit to a slow-growth area of Canada, money is unavailable or is only available at prohibitive rates, an equity partner is needed for a short period of time. Once having decided that government assistance may be applicable, the lawyer should make the client aware of the disadvantages that may come with it. The length of the application process itself can often be a problem. In practically all cases where government assistance is contemplated, one should not commence a project without having prior approval. This is a requirement under most projects. Undertakings. There are often restrictions in the sale of a business if prior funding has been obtained from government sources. the government will require continuity of these undertakings if a company which has received government assistance in the past changes hands. It's often a term of the loan the government's prior approval is required to a sale or transfer of the control of the company or a sale of the major part of its undertaking. Another disadvantage is cost. Because it is government, the bureaucracy may require much more information than what a borrower might otherwise be required to provide to a conventional lender. There's a cost attached to accounting advice and legal advice in preparing the information required. Now, the cornerstone of any application for financing, whether it be by way of equity or loan from the private sector or the government, is the comprehensive business plan. The company must know the direction in which it's going. It must have its act together. A lawyer may perform a useful function for a client by advising of the desirability of the comprehensive business plan and giving a copy of a sample form to the client and/or reviewing it with the client. An excellent form of business plan is available from ITC, and as well, the Canadian Institute of Chartered Accountants has a rather extensive one. The business plan should not be formulated in final form before ascertaining the specific requirements of the relevant government assistance program. One agency may stress certain information, another agency may not seek. The lawyer, as a minimum, could also be helpful in preparing a list of important contacts and telephone numbers. For example, the local FBDB office or FBDB Information Center, ITC, or MIT. As I mentioned earlier, the lawyer should also have a book or material on sources of funds available for a client. Once the client's been steered in the right direction, he or she can usually handle the application without the assistance of the lawyer. It's often been asked whether it's necessary for a potential applicant's lawyer to be involved in the early stages when the client is considering making an application for government assistance. A lawyer can be helpful to the client in several ways. The lawyer should carefully review at the outset with the client the type of security the client actually has to offer to a lending agency. A search against one's own client may be desirable, as there may be an outstanding debenture, assignment of receivables, other security agreements, Section 178 Bank Act security, equipment under lease, etc. Some may in fact have been paid off, but no discharge ever registered. If it's essential to close a loan transaction quickly, valuable time can be saved at the outset by arranging for relevant discharges. The client should be advised in most instances the bank or other private sector lender may require first security. The client may have to arrange for subordinations or postponements. It's better to know in advance what the lender priorities are so that the client can test the waters with the lenders if necessary. Again, if speed is essential, a head start may be desired. In the documentation stage, the lawyer has a positive role to play. Assuming a letter of commitment is offered by a government agency, the lawyer should advise on same. For example, it may be guarantees are appropriate. In other cases, they may not be. This is the kind of matter that should be discussed with the client before a commitment is signed. Now, the following are some general comments on various standard commitment letters I've seen used both by the ODC and the FBDB. I point out these are not intended to be exhaustive. Negotiation fee. It's not unusual to see a negotiation fee payable at the time of an acceptance of an offer to finance. The principal could be discussed and/or the quantum possibly reduced. Penalties for failure to close. If the applicant's unwilling to carry out the loan transaction, the offer to finance may provide payment as liquidated damages may be payable. Again, the principal involved or quantum could be discussed. Prepayment privileges. The terms of repayments may provide principal payments may be accelerated at the option of the lender by an application of a formula based on available funds. One must ensure the formula is fair. Conversely, the client may wish to pay off the loan, particularly an expensive government loan, before its due date. One should ensure this could be done at a minimum of cost to the client. Negative covenants or restrictions, they should be fair. Guarantees, personal guarantees are often required. Perhaps they can be limited to specific amounts or be made to fall off when certain events happen. Repayment of shareholders' loans. Normally, you can't make repayments to shareholders' loans until the government loan has been repaid. It may well be that there should be a formula worked up to allow for prepayments. Another area where the lawyer's help may be warranted relates to tax. There are often tax implications in receiving government aid, and the lawyer should be aware of these. Interpretation Bulletin IT 273, dated January 19, 1981, and a special release of December 31, 1981, sets out a list of the bulletins and the applicable principles involved. No lawyer can guarantee a client will be able to obtain some of the government's largesse in any one situation. The client's chances, however, of obtaining a grant or other assistance may be improved if you pass along the following guidelines. Begin by placing government assistance on your permanent list of potential sources of funds or support. Always secure the approval of a program's administrators before committing your company to action on a particular project. Plan ahead. Try to understand the government's motives and objectives in creating the program in which you're interested. Be prepared to demonstrate the government assistance you're looking for is a vital ingredient in the success of your program, and you've explored other potential sources of support for the project. Do your research and planning before submitting a formal application for an incentive program. Never assume you're ineligible until you've talked to the agency concerned. Public speaking is like taking a vacation. It helps to know where to stop. Thank you.